still have time to call you back, 'cause you've been trying to reach me. I thought you couldn't care less. Is there still time for regret? Take my life, I don't want it. You can use it better than I do. Take me now, blind feel it. Take me now, I'm bored to death. Take my life, I don't want it. You can use it better than I do. Take me now, blind feel it. Take me now, I won't regret.
Inicia ¿Qué onda? Con Eduardo Fernández, el programa más prendido de la radio, transmitiendo desde Atlanta, Georgia para todo el mundo. Síguenos en nuestras redes sociales y sé parte de la conversación. En Twitter como Rock Radio y más, y en Instagram y Facebook como Rock Radio and More. Llámanos 770-884-2104. ¿Ya bajaste nuestra aplicación? Busca nuestro app en las tiendas de Apple y Google Play y comunícate con nosotros. Adelante con un showzazo.
Con un showzazo. Esto es ¿Qué onda? Yo soy Eduardo Fernández, transmitiendo desde Atlanta, Georgia, a todo el mundo. En esta tarde, 17 de diciembre, ahorita son las 4:06. Voy a tener la primera hora una entrevista con una firma de abogados que se dedican a la protección de la propiedad intelectual. Y va a ser en inglés, lamentablemente. Después vamos a ir traduciendo algunos de los temas, los más importantes, durante la semana, en las siguientes semanas, puesto que es un tema bastante importante que nos compete sobre todo a los músicos ahorita que nos siguen en Rock Radio and More, que tocan música y que muestran videos y que son parte de la comunidad musical emergente, ¿no? Y es como un regalo, ¿no? Para la gente, para nosotros. Ahorita en las posadas navideñas estoy bien contento de tener a Marcy y a Beth Moore, pero también quiero dar de Vivid IP, que es el nombre de la firma de abogados. No se asusten, chicas. Don't be scared. I'm speaking Spanish just to introduce myself to the show. Now, let's talk about business. How are you, Marcy? How are you, Beth?
Doing great. Hello, and thanks for having us on your show, and hello to all your listeners.
Well, one of the things that I want to talk about, and I want to make sure our audience understands, is that you guys help, and also, well, in the case of Marcy, the business of your law firm, it's about intellectual property, which is, and tell me if I'm wrong, which is any kind of idea, protecting any kind of idea that it can be from a poem to the invention or the patent of the vaccine COVID-19, right? Am I right?
Absolutely, yes. Intellectual property protects intangible assets that are the expression of ideas. So there's three main types of IP, for short, is what we call it. Number one is what we're going to be talking about today, are copyrights, which protects original works of art. Think of films, music, paintings. So the song lyrics, the melody, and the recorded performances of artists are protected under copyright law. Next, we have trademarks. So those protect brand names, logos, taglines. Think of Nike, Just Do It, the McDonald's Arches, Sony. Those are all very well-known trademarks. And trademarks, they identify the source of a product or service and allow you to distinguish yourself from competitors. So they have a lot of value. And then finally, patents are a form of IP, and those protect novel and useful inventions. So in the music industry, if somebody were to invent a new instrument or a new part of an instrument, that could be protected under patent law.
Perfect. And how long does it take, if I have an idea and I want to start the process, let's say, call a lawyer like you, how long does it take for me to get it patented and make sure that I'm protected? And also, let's say that I want to develop it at the same time, and I have to share my information and my knowledge. But at the same time, I want to be protected. Can you tell me how that works? Because
Sure. Yes. So the patent process varies according to the technology and how extensive the application is. First, we often do a patent search to make sure that this invention has not already been applied for, because in that case, it may bar you from obtaining a patent. And it can take a couple of years sometimes for it to issue as a patent, or it can be very quickly. In terms of sharing it and protecting that patent and that idea, when you go to, for example, investors or another company that you want to produce your invented product, it's critical that you have a non-disclosure or NDA agreement, that you go into that meeting protected ahead of time, where it prevents that party from taking your idea and patenting themselves or marketing it for a certain period of time.
Say it again. What is it called? That kind of.
It's called an NDA, or a non-disclosure agreement.
NDA.
So yes.
So basically, if I have an idea and I'm willing to, I think it's something that is brand new, never been released or patented or whatever. I can call a lawyer and ask for one of these agreements, and then be protected. You send that, let's say nowadays you send it by email, or in that company just replies or signs, and then you can go to the meeting. Is that it a simple reply? Does that protect you, or do you have to have like a something went on my eye?
Yes, you definitely want them to execute, which is the legal term for sign the contract. You need a written contract where both you and the other party sign on the dotted line, and have clear terms that specify what they can and can't do with the information you disclose during the meeting. Usually, to be enforceable, the NDA has to be limited in scope and duration, meaning it can't be forever, or else it likely won't be enforceable, or the other party likely won't agree to it if it's too long in terms of the duration. So you have to think about what the other party is going to be willing to agree to. But yes, to answer your question, both parties should sign the agreement before the meeting.
And I would recommend someone that has an idea that do not take it for granted and take it to a lawyer, any lawyer. It could be you or it could be anyone, and read the whole thing. Just do not agree to something legally, something that you don't know. You will be protected.
Eduardo, I want to add one other point. You talk about ideas, and I want to make sure that this is clear. And a lot of people don't understand the difference, but ideas themselves are not protectable. It's the expression of the idea. So if you have this amazing song that you are thinking about in your head, and somebody releases that song, you have no remedy or recourse against them until it's called fixed in a tangible medium of expression. And that's just fancy for saying you write it down, you type it out on your computer. So you have to actually express the idea to protect it.
Very well said. Very well said. Also, when people perform a new song on Facebook or in a video or YouTube, that's another expression, right? That's a way to express it. So it will be protected from the day it was uploaded. And if I'm not wrong.
Yes, that is the first publication or fixing it in that tangible medium of expression that the copyright attaches to it. Now, if you want to enforce your copyright in court, you must register it with the Copyright Office. The Supreme Court recently held that you have to actually have a registration. An application to register it is not sufficient. So you have those copyrights, the protection upon creation, but in terms of enforceability, it really behooves you to go ahead and file a copyright application, which can be done for pretty low cost.
$35, I guess.
Yeah, and get it done pretty quickly. So that's why it's important. Also, you can recover what are called statutory damages. So if somebody releases a song and you have a copyright registration, you can obtain damages that are in the statutory range. And if you don't have the statutory damages availability, it can be harder to recover, and the damages are often not as high.
Okay. Okay. There's a question. a producer, not that producer, a producer, heard the song. Bueno, I don't understand if he means that the producer used the song and they never saw any kind of royalties. I think he's skipped to say something. If you're listening to me right now, Carlos Lares, please explain better. But let's say that idea. He used to work in a recording studio. They were doing a song, but a producer. It doesn't say the producer of the song. It says a producer. Lo escuchó un productor. And then after, seems to be that the producer did something with the song and they never saw any kind of royalties. So what can you say there?
Well,
Yeah.
Beth is our music guru, and so I want her to take this question.
Yeah, well, thank you, Eduardo, for the question, and thank you to the listener out there that asked it. My name is Beth Moore. I'm the entertainment law specialist at Vivid IP, a law firm here in Atlanta that specializes in intellectual property. And in particular, I specialize in the music industry, which is an incredibly complex part of the industry. I'd say even far more complex in many respects than film and television and other forms of creative expression. So a word of warning for all those of you who work in the music industry, it's a wonderful industry to work in, but it is far more complicated than most people understand it to be. And one of the great things about music, but also one of the challenging things about music is that it is a creative art form. And a collaborative art form, to where you can have somebody who can write and record an entire album all on his or her own with no input from anybody else. But I find that that's pretty rare. Most cases, you might have multiple songwriters, multiple performing artists on a recording. You might have a producer, an engineer, maybe there's a record label in the mix. And so the role that we attorneys play, those of us who specialize in the music industry, is we make sure that there are written agreements with everybody so that everybody is clear as to the two main things involved in every music industry contract, which is who gets to own the music at the end of the day and who gets to earn the money from it. And if you are creating music with or for other people and you don't have anything in writing expressly stating what your stake in the product is, then you're going to find yourself shortchanged at the end of the day. It is much easier and much more cost effective for music makers to consult with an attorney, get the right contracts in place, do things right the first time around so that you don't have to deal with issues on the back end. That may or may not prevent the situation that your listener described where somebody in bad faith maybe stole an idea or heard a song and then, made their own version. That's just straight up copyright infringement that you have to be able to prove in court in order to go after them. But even lawsuits are a financial investment. They are not cheap. So the best advice I can give my clients is to just protect your work at all costs and be careful who you let into the recording room.
That's a very good advice. Who do you invite to that recording thing? Talking about music, if you have an idea, tell me if I'm right. If you have an idea, just play it. Put it on video, whatever.
Yes, the most important thing you as a creator can do is to fix your work in something that is tangible, right? In other words, the song that you have humming in your head, you have to express it in some way, shape, or form that it exists in the world other than in your human mind, right? Mm-hmm. Write the lyrics in your journal. Pull out your phone and hit the record button on your app and record a demo of it.
Got
it. Perform it in front of a video camera, and then that digital file containing that digital video, that is your tangible expression.
Perfect. That's good. Also, does the witnesses in the studio help this Carlos Lares? I already respond, but he's not responding. If there's any witness there, does that help? Like the recording engineer, a guitarist, or someone?
You know, having a witness in the room can go one of two ways. Either you will have somebody there who can testify as to, you know, the facts of the events that occurred in that room, should there be a dispute later as to who contributed to a creative work and therefore who should share in the ownership and profits. But I would posit that having a witness in the room can also backfire, in that that witness might then later claim that they helped you create the work, you know, and you know, because they, you know, clapped on a recording that therefore made them a co-creator of the work, and you owe them royalties for that. So my best advice would be to clear everybody out of the room that's not involved in the creative process and who doesn't otherwise have a contract in place that formalizes their participation in the creation of that work.
So when if I hire musicians to do a job, and let's say I have my guitar, I have my chord progression done, my lyrics, but the bass player is a great bass player, that's why I'm paying, and he comes up with a better bass line that really works great. The drummer does a much better thing that I would perform. Let's say 50 Ways to Leave Your Lover is a song of Paul Simon that you can tell right there the job by Steve Gadd on the drums is what makes that song. Of course, the lyrics and the voice of Paul Simon, but those drums create the whole personality of the song. So, can you say, you know what, Steve Gadd, I'm gonna hire you. I want the best from you, but I'm gonna pay you work for hire. Is that allowed? Is that okay? Is that fair use? I mean, it's a fair deal, or no?
I think the first thing to understand with regard to your question is there's an important distinction to make in the music industry, which is the difference between the copyright and the composition, which is the underlying lyrics and melody. Or in rap and hip hop, it's more of a rhythmic art form, so it may not have a melody, it may be a more beat-oriented composition.
You're good.
You know,
Yes, she is.
You're really good. I've been reading about it. That's good. Well, we'll get to that later.
Yeah.
But
so the composition is a separate and distinct work of art compared to the recorded performance of a composition, right? So you have, those are the two main differences in copyright law, the copyright and the composition versus the sound recording. You know, in traditional melodic art forms, you know, like folk music, rock, country, you know, the rhythm section kind of gets the shaft on songwriting, right? Because if you can play the song with an acoustic guitar, then chances are that the drums and bass really only play a role in the recording of the composition. So it's a matter of who gets credited with the songwriting versus, you know, who gets to participate in just the recorded performance of the composition. And that breakdown is up to every songwriter to determine, you know, who gets to be credited as the songwriter and who's just helping you make a killer recording. And
can you pay your performers? Can you pay them and then just
Yes,
okay.
Absolutely. You know, so it's a lot easier to be able to hire somebody as a work for hire when they're contributing to the recording, whereas songwriting doesn't really lend itself to be a work for hire. It kind of, you know, operates a little differently with songwriting. But yeah, even record labels, when they sign an artist to the record label, it's not the artist who owns the recording, it's the record label.
That's right. That's very good. By the way, before we continue, would you mind if I go ahead and play song from one of our very good bands that we interview and we play here on Rock Radio and more. This band is from Spain, and they just released this very good album that it was done during these pandemic times, but they did it in such a great way. Would you be okay?
Let's do it.
Absolutely.
Great.
Bendito el día en que te conocí. Fue un disparo, una raya de speed. Agitaste todo mi cuerpo de mi mala manera. Y desde entonces vives dentro de mí. Siempre fuiste un amigo de
on Rock, Radio, and More.
My light keeps going out. Sorry.
Muy bien, muy bien. Ok, continuamos en este programa, pues bastante especial. Estoy muy contento porque en estas posadas que hemos estado haciendo, esta serie de series de Navidad 2020, estoy tratando de traer personas que puedan regalar algo, ¿verdad? Algo de su conocimiento y pues qué mejor que platicar de los derechos, ¿verdad? De autor. Muchas de las personas que nos escuchan, la mayoría de las personas que nos escuchan y que nos siguen en redes, tienen algo que ver con el arte, o somos melómanos o ejecutamos algo. Hay escritores, entrevisto personas de todas partes del mundo y personas que nos escriben, pues, y que son amigos de Rock, Radio and More, pues son artistas, y qué mejor que saber cuáles son nuestros derechos y qué podemos hacer para proteger nuestras ideas. Continuando con Marcy Sperry de la firma de abogados Vivid IP. Would you please, Marcy, explain me what is your role in this law firm overall?
Absolutely. I'm the founder of Vivid IP, and I started the law firm 3 years ago to provide protection to artists and creators in their original intellectual property works. And I call myself the IP enforcer because I specialize in enforcing and defending your intellectual property rights. So I also do a lot of trademark registration and prosecution work. But mainly, if somebody is infringing on your work, we can send a cease and desist letter, or we can sue them. And vice versa, we can also defend your rights if somebody is attacking or challenging them.
Perfect. If someone is using my logo, or how about a catchy phrase?
Absolutely. That can be called, it's a tagline or slogan. And if you're using it to sell products and services, you can protect it. One of the most famous taglines of all time, and my favorite, is Nike's "Just Do It."
Yes. Yes, I love it too. There's things that that's what I do for a living. I do slogans, jingles, and things like that. And sometimes customers, and mid-sized customers, they don't understand the importance of a slogan, right? And
Yeah, absolutely. I mean, it can be extremely lucrative. I mean, intellectual property, like trademarks, allows you to create goodwill in your name and brand. And then also you can generate revenue streams such as royalties when you license the right to use your tagline or trademark to other parties. You can also assign your rights outright and sell it for a large sum. But in music law, I wanted to mention 2 areas of trademarks that are important for bands and artists to take advantage of. And one is song titles. So while the lyrics and the composition of your song are protected by copyright, song titles are not protectable under copyright law. So another way to protect it is through trademarks. If you are selling a product or offering a service under a song title, you can protect it. Interestingly, there's a beer company called Abita that owns the trademark for Purple Haze, Jimi Hendrix's famous title of a monumental song, and they own it for beer. So nobody can use the Purple Haze and sell beer because they have that trademark registration.
Thank you so much. I forgot about, I always have asked myself, what is going on with this? Did someone Jimmy Page, no, right? You say, a song title cannot be protected.
Not under copyright law. For trademarks, it can. So the key for a trademark is that you have to be actually selling a product or service to have trademark protection. And so you can take a song title in many cases and apply to register it. You would have to be careful because if Jimi Hendrix was selling beer, he could, his estate could potentially object to that. But that is something that you can also protect through trademarks. Another area of music law where you can have trademark protection is in the name of your band or an artist name. That's critical. So, for example, Guns N' Roses, they've registered a number of trademarks in the name Guns N' Roses for musical recordings and performances, but also all the merchandise, T-shirts, posters, you name it, hats. And I was looking at the trademark office records, and just 2 years ago, a company that's probably didn't consult with an IP attorney, they filed an application for Guns N' Roses for beer. And guess who filed an opposition immediately? Guns N' Roses. And right away, this company looks like they walked away with their tail between their legs because they withdrew their application very quickly. So that's why it's important to do your research. And one thing we do at Vivid is we do trademark clearance searches. So we can go ahead and do a search of all the applications and registrations to determine whether somebody has come before you file that application.
Before it used to be, I remember it was like it was a very intensive work for those clearances that you're talking about.
Oh yes, technology has really sped up the process of getting the results. So this leads me to another area of trademark law nuances that. Why register it? Because in the U.S., you have trademark rights just on your commercial use. If you have a website and you're selling a product and service and using that trademark, you have rights. But the reason why you want to register it is because it entitles you to a number of additional rights and it strengthens your trademark. Without a registration, you have what are called common law rights, and they're limited to the geographic area where you're actually providing your service or selling your products, and that can be very limited. However, with the federal registration, it entitles you to nationwide rights. So if you are a band and you only have brand recognition, say in Chicago, and you didn't register your trademark, your protection only extends to the greater metropolitan area where you actually can show brand recognition. And you can't stop another band from using that same name in, say, Seattle. But if you had a federal registration, you can go after anybody throughout the country. And the federal registration also allows you to use the coveted R in the circle, which acts as a deterrent to infringers, and it prevents anyone else from obtaining a registration for a similar mark.
Does it protect you
services.
from foreigners? How do you call infringers?
Great question. Not necessarily. So trademarks are awarded on a nationwide basis. So just because you have a trademark registration in the US, that does not give you trademark rights in, say, the UK or Japan. You would need to file trademark applications with those specific countries' trademark offices to obtain registration. However, if there is a Japanese company that starts selling infringing products using your trademark into the US, you can stop them.
Got it.
But if they're just doing it in Japan, you need to go register in Japan. That's why we always ask our clients first and foremost, in addition to the US, which countries do you plan to enter? Because in most countries, unlike the US, your rights are based only on registration. So it's a race to the trademark office. So that's why it's important to register your trademarks abroad if you want to do business there.
That was very good. I mean, China, they do beer.
Oh, don't get me started. Okay, they are.
So
piracy is rampant there. I mean, we're facing all kinds of problems with some of our trademarks there, where a lot of times these pirates will come in and they will register all of your U.S. trademarks, even though they have no plans to do business. And because they beat you to the punch, you often can't get a registration unless you actually come to them, which is what their business model is, and you buy your rights back. So it's a problem. They are trying to pass laws there to combat it, but I have not seen those laws implemented. I'll tell you what, it can be very problematic.
But the nice thing about it is, at least in the United States, they cannot compete with you.
Yes,
and that's one thing. But they can beat you in UK, or they can beat you in Europe, right?
And that's what we do is we specialize in creating an optimal portfolio strategy so that you can optimize your IP in any country where you plan to do business. So there are ways to get ahead of the curve there. So the answer is to clear your marks early and to register as soon as possible.
There is a thinking, a kind of a culture, a collective kind of mind that makes us think that if I have an idea, let me buy the domain. Let's say I have chiposTacos.com. I got it. That's me. It's open. Is that okay? I mean, if I buy a domain name and it's .com and I got the . all the
Sure.
dots or whatever. Is that a good way to protect my name?
Timing is really important to answer that question. So, for example, you can file what's called an intent to use trademark application in the US. And that means you haven't started using the mark, right? But you have intent to use it. What happens is we always tell our clients, if you're going to file that, you better buy up all the domains containing that trademark first and foremost, because you've got these domain name pirates that monitor the trademark office records. And if they file for the domain name and they own the domain name before you start using the trademark, they could potentially prevent you from getting that domain name. Now, if somebody buys a domain name for Cartier, the famous jeweler, and launches a site that's offering or taking advantage of that brand, they can be sued for cyber squatting or trademark infringement. So the timing matters.
So if, let's say there's a new dot sodas, and I buy Coca-Cola soda, is that, so I will be sued, right?
Oh, you don't want to go up against Coca-Cola, okay? Because they do not mess around. So that's another thing.
Mess around with their...
You are going to be receiving a cease and desist letter immediately. And possibly being sued. So yes, you've got to be careful. You do not want to buy a domain name and a well-known trademark, because you are going to be a target.
Okay.
And there's ways on the other side of the equation. If you own that trademark and somebody does that, there's ways to obtain that domain name without the expense of litigation. And it's called a UDRP proceeding, and you can get that domain name within 3 months. And we have had a lot of positive experience in doing that. It's before an administrative panel.
So you go directly with whoever the domain organization, whatever, and then you take it from them. Say, that's mine, and give it to me. And where is that guy? Let me kick his butt. Some kind of thing. Yeah,
it's actually pretty fast and effective and cost effective too for our clients. It's called WIPO, the World Intellectual Property Office, and it's an administrative body of law where you file this complaint, and the other side has a chance to answer it. A lot of times the other side, they go dark pretty quick when we file this. It gets their attention. And if they know that they don't have any rights, then the WIPO will issue a decision. And if you have grounds to win, they will automatically transfer that domain name to you. Whereas if you file a lawsuit in court, you're talking 1 to 2 years, and it could be, tens of thousands, if not over $100,000 to litigate an IP dispute from start to finish.
Yeah, I mean, that's one of the problem with this kind of litigation. Tell me if I'm right or wrong. If someone, an individual is not an individual, let's say someone wants to sue me, I cannot, or I want to sue someone, I cannot do that. I cannot, I need to hire a lawyer, right?
Well, you don't have to. It's called representing yourself pro se, but I would strongly advise against that, because you are going to get your clock cleaned if you do that. So basically, yes, you need to hire an attorney so that they can represent you effectively, because the nuances and the elements that you have to prove can be very complex.
Yes. Well, for why I can, that I always recommend my customers, since I sell creativity, that's what I've been in business. That's what I will always recommend my customers. Number one, that they pay attention to the creativity of their business.
Yes.
It's not just that they sell this or they buy this, or, they make money doing cleaning or whatever. The most important thing is that they protect all the assets, not just their trucks, their businesses, their tools and so forth. But also all the intellectual property, which is ideas, name, logo, uniform colors. Is it right that the Tennessee, the university? The university, I got the hat there signed by Bill Battle. I heard that color, that combination of orange, yellow. Can you patent it? Can you?
You can. That would be a trademark. But yes,
sorry.
That's okay. You can trademark colors. You can actually trademark sounds and smells, if you can believe it. So yes.
Sounds of what?
Sounds, certain sounds like MGM Studios, the lion's roar. That's protectable.
Okay.
T-Mobile owns the registration of the color magenta, and smells even. Play-Doh, the smell of Play-Doh is a registered trademark, if you can believe that.
Oh my God. Yeah. Okay. It's funny. It's funny. There's some cars also that I always wonder why this car, I don't want to mention the name of the car, but always been the same smell. I don't know lately because I haven't buy one in recent years, but that is an awesome car. It's very well known German car, and the smell it's been the same for decades. I don't know what they do in there, but now that you're telling me that Play-Doh, that smell can be, you said trademark or?
Yes. There's also, in the music industry, there's a ukulele company that has registered the smell of pina coladas for their ukuleles. So pretty cool stuff.
That's a good one.
But you know what? Scent is the most evocative sense. It is really powerful. So it's can be pretty important in a marketing standpoint to distinguish yourself that way.
Thank you so much, Marcy, for that information. I think he kept going, said, yes, they used the song and never got paid. And they sold the song. So, okay, we'll get back to this answer to Carlos Lares after probably Beth Moore with Vivid IP. Explain me, where are we? Let's say right now, I wanted to play this song very quick, right? This is very, I don't know if this is, I don't know if you recognize this. Okay, that song is called Breaking the Law. Me playing that live on Facebook. Am I breaking the law?
Well, Eduardo, I am not your legal counsel, so this is not legal advice. But
I have to pay you, right? Oh,
that's right.
You okay?
But what you asked relates directly to what we were talking about earlier with the distinction in copyright law, which is that somebody had to sit down and create and birth into this world the song that you just played, right? It's some human being out there came up with that creative original idea and encompass that in a way that the rest of the world could hear it and enjoy it. And in some cases, use it for commercial purposes. Well, when you create something, right, you are the author of it, you are the creator. Copyright law confers upon you, all rights to that. That nobody else can come along and steal your work and pass it off as their own or try to make money off of it. You own those rights unless or until the day arrives where you license those rights to other people or sell them to someone else. And when you think about the term copyright, you can boil it down to the word itself. Copyright means the right to make copies. Beyond that, you can also think of it as a bundle of rights, that it's not just the right to, create, a recording and sell those recordings on iTunes. It's everything surrounding the use of that work. Licensing it to someone else to record it, performing it in front of audiences, allowing radio stations to play it on their airwaves. All of those different types of uses are encompassed under copyright. And so when you perform somebody else's copyrighted work on a distribution platform like Facebook, that's no different than Spotify having to get the rights to distribute that on their platform, or if ABC wants to put it into a television show, they have to get permission for it. So the bottom line is you need permission from the copyright holder to perform it. The good news is that the music industry is also built on some of these issues to where there are processes in place that can make it easier for you to acquire perform. and Facebook can play a big part in facilitating that licensing, just in the same way that YouTube has updated their platform, so that if you want to play a cover song and upload a video of that cover song to YouTube, YouTube has a process in place to deal with it. Either the copyright holder has instructed YouTube to immediately take that video down, or perhaps they'll monetize it and send the advertising revenue to the person who wrote the song, the person who owns the rights to it. So platforms need to update if they want to accommodate some of the more popular uses of music. I think about TikTok, as a platform that has really built itself on a modern version of what it means to license music.
On our radio, we pay every year. We pay ASCAP, we pay BMI for the music we play, right? The rights to play the music on rockradiomore.com. But when I play that on TikTok, I'm not doing it. I don't play the music from here, but I just play the guitar from 1 minute or something, just to promote the song because the song was released that day, or some kind of the intention is to promote the music, right, and the artist. But I can be in trouble. That's what you're saying, right, Beth?
Yeah, it sounds like in this hypothetical scenario that you've not received the express permission to make the song available to audiences in the way that you described. That's really the sole right of the rights holder to determine when, where, and how that's used. And so in the case of TikTok, when you have those music clips, the up to 60-second music clips that are available that you can put behind your videos, there is a license in place where
which is good.
The person who wrote the song and the person who recorded the song has given the platform permission to make that
That's
available.
That's right. But not me playing it with my guitar and my own sound. That's not right because I'm not. So I am so sorry, Mr. Angus Young. I'm so sorry, Stone Temple Pilots, Led Zeppelin, Steve Howe, and all those of you. Please, I'll be happy to pay you, but like a beer or something. I'm not gonna do it anymore. And also Judas Priest, that they owns that beautiful song, Breaking the Law. Talking about this, can we go a little bit over this very good or very, very interesting note that we've been talking in our show, and is Bob Dylan selling his music, his whole catalog to Universal. And I think it's for $300 million. And we've been discussing this with different people, if it's a good idea, bad idea. In my opinion, that was a great idea. He's 79-year-old. I don't know. He probably is going to live 100 years, hopefully 120. He's a great person, a great guy in music. And he was the first artist to be uploaded on iTunes. And anyway, he was he's a Premio Nobel Prize for literature, the first musician ever. Mm-hmm. Am I right? And then, can you explain a little bit the process on that, and does he still have the right? Let's say he's giving away the whole catalog, for some money, right? The whole $300 million. And what does that mean? I mean, they can do movies and he will not get any money. If Donald Trump wants to use his music, can he use it now and he will not complain? Tell me more. Can we talk a little bit about this?
Sure, yeah. Well, it comes back to the distinction we made earlier, right? The difference between the ownership of the composition copyright versus the sound recording copyright. And in this case, we're talking about the composition copyright. Bob Dylan is, as you noted, a absolutely prolific songwriter, arguably one of the most prolific songwriters of our lifetime, as evidenced by him being the only songwriter to receive the Nobel Peace Prize in literature, right? So it's an acknowledgement that he is a wordsmith, that he is first and foremost a songwriter. We just also happen to identify Bob Dylan as, having that unique voice that we have all heard through his recordings. So he sits on both sides of the copyright equation. He's both the songwriter and he is the recording artist. But this sale of $3 million is only in relation to his songwriting career. what this means is that the entity that purchased his what we in the music industry call Bob Dylan's publishing rights, that means that this new entity is now the owner and administrator of the rights associated with the lyrics and the melodies that Bob Dylan has written, throughout his lifetime. And it is, I think there are over 600 songs in this catalog. There are some carve outs, so it's not every song. There's a few that he kept out of the sale. And it also does not include any future songs that he writes. It's just a certain catalog that he's written up to date. What it also means is that Bob Dylan has not permanently, capped his earnings on these songs at $300 million. He is still going to earn ongoing lifetime royalties, and then his estate will earn royalties on those songs after he's passed. But there is a publishing entity out there that has determined that his catalog is so lucrative that it's worth it for them to be Bob Dylan's business partner and then split the proceeds that are earned between him. I presume that they're splitting them 50-50, but the details of the sale are confidential.
Isn't that great? Imagine that. You're 79-year-old and you get $300 million just for all the stupid things that you thought about and you put them on a writing and you made a song and then you go play. Well, it's a lot of work behind because people say, well, he was a good idea. He was a good writer, good composer. Not just that. He went through a lot of crap, allow my French, and a lot of stuff, putting up shows and dealing with a lot of musicians and business people and sometimes issues and all that. I mean, there's a story behind all these $300 million, right? But it's so good, right? That they did they got the songwriting correct. I mean, what I'm trying to say, how important is that we write, we protect, right? We have an idea, we express it, we protect it. Am I a good thing you want to say about it, Marcy, about this?
I think you just summarized it extremely succinctly and well. Yes, remember that if you have an idea, you need to express it, write it down, type it out, record that performance, and then register it with the Copyright Office. If it's a name of your brand or even the name of your band, you want to register it with the Trademark Office. And if you have an invention, you want to file a patent application. So yes, you definitely want to express it and then protect it.
This is very, this one thing, is there anything that we are probably missing that you would love the audience to know?
Don't underestimate the value of intellectual property. Some people say, well, why protect it? Because like real property, you can sell it, you can monetize it, you can create lifelong revenue streams through royalties. So just remember how possibly lucrative these assets can be. And also trademarks in particular can create a specific goodwill or brand recognition that instantly allows your fans to associate that brand with you.
Yes. Thank you so much. I don't know what happened with Beth.
I don't know either.
I would recommend to always seek for legal help to protect your business. Your ideas are very, very are your assets. Para todos mis amigos, los que les quiero decir es que yo sé que muchos amigos míos hablan inglés, muchas personas que escuchan rock hablan inglés o lo entienden muy bien, y yo sé que muchos entendieron casi toda la entrevista. Lo que queremos decir es que si tienes ideas, pues exprésalas y protégelas. Y no solo eso, no es si tienes ideas, no, ten ideas, hay que tener ideas. Muchas veces, and this is something that it really gets me nervous and mad, Marcy. Are you there?
Yes, I'm right here.
It's that many times people doesn't even want to get into the idea. It feels so bad when someone steals something. That I know this because it happens to me sometimes. You know what? I'm giving up on this. Someone is, if someone took your idea and they didn't pay you, or they did not promise you, whatever it was said, they
Right.
didn't deliver their part, and they got your idea. And
Yes.
sometimes you just say, well, whatever, they're friends, they're good. No, there's no friends in this. And if they're your friends, well, try in honor to that friendship, just do it right if you really want to keep that friendship alive. Never, if a friend gets mad because you say, let's sign this, then he was not your friend, I guess.
Yes, that underscores the rule that be careful mixing business with friendships. So you definitely need to treat any type of business relationships with friends as a business transaction and get the agreement in writing ahead of time to avoid that situation.
That's great. Well, anything that you think I'm missing, Marcy, that you want to say? Do you want to say something quick about your law firm?
Absolutely. Vivid IP, again, we protect artists and creators and content creators, and we help you protect and enforce and monetize your valuable trademarks, copyrights, and patents.
Great. What is the slogan of?
We have two, Dare to Dream, and also don't just make your mark, own it.
Yeah, I love it. I love that one. Well, I'm gonna go with a very good song here of friends of mine. This band is originally is from Belgium, but my friend that plays in this band is called Tank Rogue. I've been having here in interviews, and also we play their music. He has this project that he does globally with different artists.
Oh,
It's
cool.
so cool. It's Project Pangaea or something like that.
Well,
I'm sorry?
I just said that's so cool. And I just want to, before we close out, just say thank you so much for this opportunity and for the opportunity to connect with your listeners.
Great. No, it is a pleasure for us. I'll think that I know what I'm going to respond in a little bit on writing to Carlos Lares, but you're welcome to respond to him in Spanish or in English. And if he has an issue, I'll translate it. It's in the video. Thank you so much. A todos, yo continúo hasta las 6 de la tarde aquí en Rock, Radio and More. Hoy es 17 de diciembre del 2020.
Project Pangaea. This is our new single, Last Summer. You are listening to Rock Radio and More. Turn it up!
Are we off?